Yeah. Yes, what is the better?
Lord, this is a bunch of matters.
My Lord, before we begin, I have got a very humble request to make. This matter has been decided on 3/5/24 and it has not been revived. So, my Lord, with utmost respect, my Lord, I respectfully beg to submit that it has wrongly been again listed for rehearing. There's no order remanding or reviving the writ petition. It has been decided.
3/5/22.
3/5/24. Matter has been finally decided.
24. Where is that order?
Pardon?
Show us the order.
3/5/24, it has been finally decided, my Lord. Nothing remains to be decided now. That Supreme Court order dated 18, my learned friend will lead the argument, but at the outset, I want to humbly request
Yes.
Supreme Court 18/12/24 order may be seen. Supreme Court has not, my lord, revived the, and this petition is filed by only two petitioners, and total 11,484 people have been appointed, out of which, my lord, 484 are appointed after 11/8/2023, because of which, my lord, their appointments will have to be cancelled. That's a different issue. I am not one of those. I am one of the 11,000 people who have been appointed prior to the judgment dated 11/8. So the starting point, my lord, 18, my learned friend will begin with 18/12/24, I think.
Well,
And
you don't think about me, please. I'll argue it in my own way.
Yes. Not nothing. I think the WP is not revived. It's at the outset my humble request. As my lord is pleased, or my learned friend will proceed in his own way.
What simply, my lords, in the earlier round division bench has said that because the matter is sub judice before the Honorable Supreme Court, whatever is decided would apply. Now the Supreme Court has very clearly held that the diploma is the only qualification. The B.Ed people have wrongly been taken in. Now there are subsequent clarification which says from which point this could apply if there have been already recruitments. Now in our case, we had challenged, these rules were under challenge, everything, but all appointments, one to last, have been made subject to outcome.
Listen, in order dated 3rd May 2024, this was also petition.
Below?
Yes.
This 595.
Yes.
Yes.
Come to the last paragraph. What about the liberty party?
My lord is referring to the earlier round of the High Court order or the Supreme Court decision? Supreme Court clarification?
Para 9 se particularly the petition qua ground 6.11 and relief clause 7.5 have assailed the validity of and legality of the column 5 of schedule 3 of rules 2018, but no arguments in this regard were extended by the petitioners. However, considering the importance of the said issue of validity of the rule 2018, petitioners are granted liberty to raise the said issue separately by way of a petition. In view of our discussion and fact that majority of the relief claimed by the petitioner diplomats having already been granted by the apex court, and in this regard to the remaining causes of action, liberty has been extended to raise as and when the same arises. This court declines to proceed with these matters and dispose of. Right. Then why these petitions are listed now?
They have been revived by the Supreme Court and sent back.
Which orders of?
Well,
18/12/24.
इसमें this 595 petitions, yes, that is argument, yes. White order dated
18/12/24.
18/12/24. This was the petition.
A6 बोल रहे
This order is 17th May 22. So this petition was disposed of on 3/5/2024.
Yes.
So then how this order is applicable, Mr. Sharma?
Miller?
How this order is applicable? This is
Supreme Court's order.
2022.
Yeah.
And-
The one of the petitioners here, Vipin Kumar Trivedi, had gone to the Supreme Court, and it's therein my lord this entire issue got decided.
तो जो द्विवेदी गया होगा
जी.
तो वो तो उससे डिसीजन से पहले 3/5/2024 order is 3/5/24.
जी.
That is order passed by the Supreme Court. That is 17 May 2022.
1812.
No, 1812,
18/12/24 you say.
Yes.
But this order is 17 May.
No, 1812.
My lord, will you please to see 1812?
मुकेश जो गया था.
1812-24. 1812-24.
A16, page 167. There's a compilation filed by us.
54 the number.
1812-24.
SLP. So this is order dated 18/12. Yes.
जी.
Yes.
We can read this, Lord, with my lord's hand.
Just a minute.
Yeah.
The 595 is also mentioned. in it.
Yes, 595.
Right, that is also mentioned.
A large number of petitions were decided by this court on the issue of qualification required for primary school teachers. In a judgment of Devesh Sharma, reported in so-and-so, we had held that the qualifications for a teacher who is taking class 1 to 5, that is primary classes, is diploma and not B.Ed. We have lost on that point. Subsequently, by the order dated 8/4/24, we had clarified that the appointment of those B.Ed qualified candidates who in the selection process were selected and subsequently were appointed prior to a judgment in Devesh Sharma, Supra, dated 11/8/2023, will not be disturbed. The order passed by this court in MA diary number so-and-so is as follows. In the given facts, we find that the question as to whether the judgment would be prospective or not was not stated by us in the judgment delivered on 11th August 23. Ordinarily, a judgment acts retrospectively unless it is specifically stated to be otherwise. Moreover, this matter has been heard on several occasions and the point urged by the respective parties have been taken note of by us. As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to the final outcome of the case, which might have had been instituted by them. And such candidates were in regular employment without any disqualification and were appointed in persons over notice of advertisement where B.Ed was stipulated to be a valid qualification. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment was delivered on 11th August 23. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. So 484 candidates go. Moreover, the candidates having B.Ed qualification whose appointments are protecting in this judgment will have to undergo a bridge course, and we direct the educational authorities to devise such course which would be applicable for each state and union territory within a period of 1 year from today. This course shall be only for those appointees who have been engaged with B.Ed degree only in the subject post under conditions stipulated in the earlier part of this order. National Council for Teachers Education shall design such course under overall supervision of the Ministry of Education, Union of India. Upon formulation of such courts, the same shall be publicly notified, and a number and a time frame shall also be given within the respective candidates shall participate therein. Failure of any such candidate to participate and complete the course within the time frame to be given by the concerned education authorities will invalidate such candidate. ये सब हो गया हमारे पक्ष में, no problem. We also make it clear that the directions contained in this order shall not be confined to the applicant state only and shall cover all cases which may be pending in different judicial or in any in any state or union territory on the same point of law. The present application stands disposed of in the above terms. Pending application shall also stand. Now, in spite of our order and the subsequent clarification,
This is to be disposed of in view of the Devesh Sharma.
Devesh.
Right.
In Devesh Sharma Supra and the subsequent clarification, we have absolutely no doubt in our mind that we had made the position very clear, both for the diploma candidates as well as for the B.Ed candidates, where they stand. Although the division bench of the MP High Court has taken note of our judgment, but we would appreciate if on the basis of that judgment, it would pass subsequent orders on all the pending applications and petitions on all the points which has not been decided in the said judgment.
So therefore Devesh Sharma has to be taken.
Yeah, exactly. My lord is right.
What happened in the
Now,
Devesh
in view of the aforesaid, we dispose of these special leave petitions with request to do the needful. Now, my lord, what are the issues which are left undecided is the moot point before my lord. And what are the petitions, my lord, which are pending? As far as present WP 595 is concerned, it has been disposed of.
They are B.Ed or diploma?
We are all, no, I am appearing for the respondents, my lord, who are B.Ed and who are working and who are appointed prior to 11/8/2023. My learned friend, senior counsel, Mr. Gildial, is also espousing their causes. And the petitioners are those two of the candidates, only two of the candidates, all others have left. Two of the candidates who are not B.Ed, who are DLEd, and who have won.
They are not.
They are not B.Ed, they are DLEd. They have the right qualification. We have the wrong qualification.
Okay.
So, my lord, but my appointment is 8/4/2023, many months prior to, my lord, the date of the passing of the judgment. And on the date of the appointment, my lord, the appointment order does not have a recital that your appointment is subject to.
So therefore, in view of the Devesh Sharma, we have to take the view in these matters.
Yes.
That's all.
Yes.
On the pending writ petitions and applications.
Right.
So there are some petitions pending which the learned government had to take.
No problem. So then
There are two issues, Lord, which are pending. Number one is inter-se seniority between the B.Ed and DLEd candidates. And number two, my lord, is, my lord, the constitutional validity of some rules, which your lordship will find in the judgment dated 3/5/24. My lord may come to the judgment dated 3/5.
take note. This will be wide order dated 18/12/2024. While disposing of the appeals pending, writ/appeal pending before the Honorable Supreme Court, directed as under Devesh Sharma last parallel. The parties are directed to file written submissions with case law dialogue to that effect within 2 weeks. Then least week commencing 1st April. 1st August.
Only the order of the Supreme Court is given. But I think it's
That's all. So you just put your submission.
Yes. Because of the private, most of private.
Yeah, last column, reproduce in Devesh Sharma, last one. Second week, last one in line.
Serial number 23.
Those who have not filed, those who have not filed.